that we do have some information that we'll share with members of the public with regards to how we fared under these same or similar processes in this Fourth Republic since we started using the 1992 Constitution. Jay is at the board and he will take us through some of the salient points, and lawyer, feel free to offer us extra education if he makes a point that you want to contribute to. So, Mr. Gabra, what can you tell us?
Thank you so much, Thelma. Welcome, lawyer. And so these are petitions for removal against Chief Justices under the Fourth Republic. Call details of the petition for the removal of Chief Justice Gertrude Tokonu. The petitioner, Professor Stephen Kwekwa-Asare, date of petition was the 17th of December 2024. It was received at the Office of the President on the 18th of December 2024. The legal basis, it's invoking Article 146 of the 1992 Constitution of Ghana, which provides for the removal of the justices of superior courts. Yes.
Next slide.
And so the reason for the petition, yes, an attempt to increase Supreme Court justices alleged that Chief Justice sought to increase the number of Supreme Court justices beyond constitutional limits. President's determination that Chief Justice did not attempt to amend the Constitution. Her request was within legal provisions. And also reconstitution of judicial panels and transfer of judges. It was alleged that the Chief Justice arbitrarily reassigned justice without explanations. President's determination, the Chief Justice has legal authority to manage judicial assignment under the Courts Act. And also issuance of practice directions and administrative guidelines. It was alleged that the Chief Justice issued guidelines that usurp the role of the Rules of Court Committee. The President's determination, the Chief Justice acted within her legal powers to ensure efficiency in the judiciary and handling of case between Daniel Ofori and EcoBank. It was alleged that the Chief Justice manipulated case assignment to favor one party. President's determination, no evidence provided to support this claim. Case assignments followed judicial procedures and public disclosure of the petition. Petition was circulated in the media before being officially received by the President. The President's determination, this breached Article 146, Section 8, which mandates confidentiality in impeachment proceedings. The breakdown so far. So the President's determination, the Council of State reviewed the petition and found no prima facie case. The petition lacked supporting evidence and was dismissed as frivolous and vexatious. The President ruled out that proceeding that the petition would undermine judicial independence and violate legal standards. So the success of petition then, the petition failed. That was, yes. So Article 146, which is the removal of justices of superior courts and chairmen of regional tribunals, Section 1, a justice of the superior court of or a chairman of a regional tribunal shall not be removed from the office except for stated misbehavior or incompetences or on grounds of inability to perform the functions of his office arising from infirmity of body or mind.
Okay, Jay, thank you. I think that we'll come to you as and when we need some clarity on some of the provisions under Article 146, and then we'll get into it. So, lawyer, we've had conversations about this before in the past about the process, and you have always maintained that the President is following the constitutional process. Do you still believe that that is the case?
Yes, that is the case. Because if you read Article 146 or even the Constitution as a whole, you will see that it will be very wrong for anybody to think that we have a democracy in Ghana. We only have a constitution. We don't really have, or do I say, we don't yet have a democracy. We have a constitution.
So what have we been doing all this while?
Let me tell you. If you get a paper and you draw a very beautiful tiger on it, and now everybody seeing it say, yes, this is a tiger. It remains a paper tiger and not a real one. See, in 1992, before we could enter democracy, there was this consultative assembly. Yes, consultative assembly, handpicked by the then Provisional National Defense Council to draw up the 1992 Constitution under severe international pressure. Now, the situation would have been different if the powers that be then behaved like the 1979 scenario. In 1979, General Ekufu, who caused the setting up of the Constituent Assembly, was not interested in contesting as a president, just as the Supreme Military Council was not converting into a political party. He was overthrown midway. Then Flight Lieutenant Rawlings came with the AFRC. Both the chairman and the council were not interested in contesting. So in that case, there was a dispassionate attempt on their part to ensure, when I say this, rather I should say a disinterested effort on their part to put in place constitutionalism. In the case of the 1992 scenario, the Provisional National Defense Council was interested in actively participating in the Fourth Republican politics, and therefore transited itself from PNDC, as you know, to the NDC. And then the same powers that the military leader was otherwise enjoying in a military dictatorship under the junta, was put or were put into the 1992 Constitution. That is why in the 1992 Constitution, you find the president so powerful, appointing and dismissing everybody. And if you want to challenge it, you say, no, it is in Article so and so of the Constitution, having power to expand the limit of Parliament, appointing the Electoral Commission, appointing his own Auditor General, his IGP, appointing Superior Court judges and dismissing them. So instead of separation of powers, as we had under the 1979 Third Republican Constitution, and when you say separation of powers, we are talking about the judiciary, we are talking about the executive, and then the legislature, the three being equal, and then checks and balances working, and then the judiciary having additional advantage of being independent of the two. In the case of the 1992 Constitution, I'm saying that it's not a democratic constitution, at best a paper tiger, simply because we have one creature called the executive with two wings. One is the judiciary and one is the legislature. So we don't have separation of powers here. And why do I say two ways? Let me start from the legislature. Members of the legislature are elected by the people of Ghana. The moment they enter Parliament, the executive has got power to enter that house, look at the faces there, and select about 2/3 of them as his ministers. So here you see the encroachment of legislative powers by the executive. And to make things worse, these same people who are selected as ministers of the president will go and take cabinet decisions and come back to defend the decisions there. Again, to weaken them more. Because at the time the member of parliament was campaigning under the 1992 Constitution, let me start it where. You see, under the 1979 Constitution, the member or the candidate campaigning to become a member of parliament would not tell you that I will give you water, I'll give you market, I'll give you this or that, because he knows that his destiny is parliament and he's not going to be a minister because of the separation of powers. In the 1992 Constitution, the candidate is now empowered to tell the people that I'm going to give you this, I'll construct you, because potentially the president would appoint him as Minister for Roads and Highways, Foreign Affairs, Minister for Education, Minister for Interior. And when he's Minister for Interior, he can get plenty people from his constituency to join the police service or whatever, the others, prisons, name them, fire service. So you see the scenario.
So then in this case, is this a healthy accountability exercise or an executive, a constitutionally enabled executive interference in the judicial process?
Beautiful, constitutionally enabled. As a result, you drift away from democracy. So it is just like saying that you want water to drink, and then we put some liquid here and put the paper tag on it, water. When you drink, it's not water. And let me make things worse for the legislature. Because you look up to the president to appoint you as a minister, you ensure that you don't offend the chief executive of state, and that's the president. So you are completely a wing of the executive arm. Now let's go to the judiciary. It is not equal party. It is a wing. Why is it a wing? The constitution says the president will nominate all judges of the superior court, that's the especially court of appeal, and then the Supreme Court. So it means that you see executive encroachment to that angle. And to make things worse for them is what has happened now. That when someone would want to petition for the dismissal of a superior court judge, I haven't mentioned the chief justice here, superior court judge, you petition the president. So you see the president smelling in here. You petition the president. Now, in the case of an ordinary superior court judge, when you petition the president refers the matter to the chief justice. Then the chief justice will weigh it whether there is merit in it. Whether it contains merit is the Latin term prima facie. So when he sees that there is some merit in it, now he engages the judicial service, or judicial council, the judicial council. Now the judicial council sets up a committee of 3. That committee of 3, their duty is to appoint 3 judges and leave the 2 to be appointed by the chief justice on the advice of the council of state. So you see that substantially the work of the judiciary in the dismissal of an ordinary judge of the superior court is that of the judiciary, within the ambit of the judiciary. About 90%.
But when it comes to the chief justice,
when it comes to the chief justice, see the way it is crafted to make the president sack the chief justice so easily. This time, when you send the petition, it does not go to the judiciary arm of government. It goes to another arm of the executive. That is the Council of State. It is an arm of the executive, Council of State. So when it goes there, the 2 arms, the president and the Council of State, who technically are not lawyers or judges, now sit down to determine whether there is merit in it. Look, the mere fact that the president sends it to the Council of State for them to determine, makes it to determine whether there is prima facie case or not, becomes a political decision.
So it was a done deal the moment the petition was sent to the president. And how does that affect the public perception and public trust?
Because the question is an excellent one.
Okay.
Under the 1992 Constitution, if you were the Chief Justice of Ghana and you discovered that somebody filed a petition and it was summarily thrown out, like the Dr. Kweku Asawan, then you know that the president is courteous to you, he likes you. On the other hand, the moment you see that the president says there is merit in it, because that's what the Council of State is saying, then if you are smart, you quickly resign. Because there is no way you will have your head in peace. And what am I saying? Unlike in the earlier situation where we have 3 judges, and judges always have a reputation to protect, weighed against only 2 members of the public. Here, you have only 2 judges weighed against 3 people, all selected by the president. And my sister, in life, who would pick a knife and give it to his enemy to stab him? I will never do that. So the moment the president begins under the 1992 Constitution to taking those steps, you should know that it has been predetermined that you will go home. And here I don't mean President Mahama, I don't mean Akufo-Addo, I don't mean anybody. I mean the fact that we are practicing constitution without constitutionalism. When you talk of constitutionalism, we are talking about a constitution having the international best practices that we are supposed to see in every constitution. And when we talk about just a constitution or the constitutionality of an act, anything that can be pointed to the constitution as having a foundation without necessarily being democratic. So what happened in 1992, I will say that it's not strange, because when you read the very subject of transitional justice, it tells you that in every situation, and it happened a lot in Southern America, that the military junta would want to convert into partisan politics. In all the situations, as I have said, the constitution is crafted to suit the military. So what you do is that you wait, because no matter what, they will not win or they one term, just as they will not lose at all. They will win both. So after ending their term of office, the military, like PNDC, became NDC. So at that time, between 1992 and the year 2000, it was just military. When the moment the leader leaves the scene, then the
that should have been the opportunity to
the
change.
next government that comes now continues the process of democratization of the country.
But in this case, if the person who superintended over the judicial system herself mistrusted the system when these latest petitions were brought against her, and mind you, this is just one out of 3 petitions that have been brought, the reports of that. How can the ordinary Ghanaian then trust that outside or within that same judicial process that did or appeared for some to have not protected the Chief Justice, they, as ordinary Ghanaians, can be protected or granted a fairness or a fair process in their own judicial processes if they are also presented to same, devoid of political motivation and those conversations? How do you build trust in people after a whole Chief Justice has gone through this and has failed against the system?
There are 2 ways of building the trust. The first one is to make the meaning of Article 146, which we are dealing with now, so clear to the people, for them to know that what is happening is not the fault of anybody, but it is something that is written in the Constitution, like something that is in the Bible, which has to be followed by Christians. That's one way of doing it, so that everybody, excluding the Chief Justice, that's her personal opinion, that she hasn't got trust in it. Why shouldn't you point to us areas that the committee or the president faulted? The reality is...
She did say that in the first instance, those petitions were not even sent to her before they were made public.
They were, Article 146 does not say anything should be sent to you.
So it's one of the areas where people
That's
are saying
her own
we
problem.
need to...
Her misunderstanding of what is in Article, her deliberate misunderstanding of what is in Article 146.
So some have suggested that to avoid the ambiguity, make it clear by putting clauses in there so that we know that there's a clear progression of events from when the president receives a copy of a petition and what happens next and then subsequently.
You see, this is what we have. And I was trying to make a point that democracy is not achieved in a day when a country is moving from a military dictatorship to a civilian democracy. We don't get the democracy that day because the very soldier or military man is going to contest, and he is also supervising the building of the new constitution. So being human, it will go his tilt into his side of the angle. And we are saying that it is just a transitional process. It is a journey. So the moment the person leaves, the next president, and luckily for Ghana, we had the next president who was a lawyer, a very senior lawyer, Mr. J.A. Kufuor, who knew that the constitution was a transitional constitution and did nothing about it. And then another president came, wanted to do something. He died midway at Amos. Then another person came who is defined in Ghana as a constitutional lawyer. And we also saw that in his campaign, he promised Ghanaians that he will change the constitution because it was very bad. And I know it is very bad. Now, when he was leaving after 8 years, his last interview, he specifically said nobody should touch the constitution, something that he had earlier on said is not that good. So now we are seeing the evil effect of Article 146, and the evil effect of this is that the dismissal of the Chief Justice does not become a judicial act, but a political act of the executive. The person who petitions is not a member of the judiciary. The one who receives it is not a member. The one who advises the court sitting somewhere, Council of State, is not judiciary. The team that set up with a marginal judiciary. As a result, the whole concept becomes what? That of the executive, because it is the president who appoints the 5, and especially the last 3 should be his own people. Look at our friend Domelevu, whom Akufo-Addo offended, whom the judiciary, Dr. Konu, offended. And naturally, if this man is there and he's a human being like Anochi, what do you expect this man to do?
So is this then pure vindictiveness?
I won't say vindictiveness. It is an example of the inefficiency associated with our constitution. And my argument, Thelma, is that if we litigate over this mobile phone and it gets to the Supreme Court, they will assemble 5 Supreme Court judges. Now you are talking about an attempt to dismiss the Chief Justice of the land. Here, I believe that you will need to assemble 7 justices.
Not 5
Not
members.
5 members
with
to
2 justices.
No.
Okay.
And then also, I believe that the report should be sent to, let's say, the Judicial Council to be vetted. But this one, it goes to the president.
Should we define stated misbehavior? Because we've seen key figures, including Madame Sophia Ekufu, a former Chief Justice herself, coming out to say that the reasons cited in the report, which recommended the removal of the Chief Justice for stated misbehavior, were too weak to warrant her removal. Other people have also come out to criticize this process and the reasons that were attributed for that decision.
Where she's completely wrong is that, the fact that in our law, stated misbehavior is not defined or explained anywhere. So therefore, the committee that sits down will put its own definition of stated misbehavior to whatever they are doing.
So alleged misuse of, okay, go on.
And then also, prima facie, whether it has merit or not, it's also not defined by the constitution or anybody in the country. As a result, when the president picks it, when the president is not a court, you see, when it comes to an ordinary judge, it is the Chief Justice who should weigh it whether it has got merit, because she belongs to the judicial system. She's operating within those lines. In the case of the dismissal of the Chief Justice, you give it to a politician to see whether it has got merit, and that's what you mean by prima facie. And prima facie is not determined or defined anywhere. And so the president gives his own personal definition of what is prima facie, and that is where the former Chief Justice also gets it wrong. He should have told us that it is weak because in the constitution, prima facie or whatever is defined as so and so. Stated misbehavior is defined as so and so. He doesn't tell us the definition of stated misbehavior, and then you arrive at a conclusion.
Okay, let's engage another lawyer who is also a political analyst, lawyer Eko Abraham, and get his quick thoughts on what the political implications are for all of this. Lawyer, thank you for making time to join us this morning. I want to understand, from the political standpoint, what has Ghana communicated to the world that we are a country that does what?
Thank you very much, Thelma. Good morning to you. Good morning to your panelists.
Good morning.
And good morning to your... personally, I think that the removal of the Chief Justice and all comments that are following are basically footnotes to what has actually happened in camera. In terms of what we have shown to the world, basically, what has happened is not illegal. It is not against our laws. So, in strict compliance of the law, we have been within the law. However, it has revealed certain cracks in our laws, because Article 146 has always been a problematic, article in the Constitution. It has always needed a second look, but successive governments have overlooked it. And for me, this presents us a very good opportunity to touch that article. And if things are done right, then I am sure that some of the comments that are coming up, the brazen and overt implications of, political hand and underdealings and all that will be minimal, But you see, my problem is that we seem to think that anything concerning the justices of the Superior Court of Judicature, especially when it comes to the Supreme Court, is non-political. But there are a lot of politics. Even the appointment of the Chief Justice, it is political. The appointment of justices of the Supreme Court, it is political. We have had instances where certain people who were deemed as seniors at the bench being skipped for others to be appointed. And in the oft-cited case of Ghana Bar Association, so everything has had a certain level of political dealings. That is why it is very important that when it comes to issues such as removal of the Chief Justice, then it is very important that we remove this kind of political dealings and then deal with it basically with a lot of layers. Because when you look at the Constitution, when you look at the removal of the president, the removal of the Speaker of Parliament and all that, you realize that the removal of the Chief Justice is the easiest. It is the easiest. And look at what has happened. And for me, nobody can say that the law has not been applied. Just that the law can be applied in the midst of mischief.
So is this mischief at play then, if potentially there is a way that the political class could sway this and make this, like you say, politically motivated, could this be an interpretation for some as one of these instances where the Constitution has been used to further a political cause?
Well, I wouldn't say that the Constitution has been used to further a political cause per se, but I would say that the Constitution has been applied in a way that we think should have been, in a way that we think shouldn't have been so. Okay, so when I look at the grounds for the removal, my basic question is, were the things that the former Chief Justice was accused of, were they true? Now, if they were true, are they enough to remove her? If they are not, what are the enough grounds to remove her? And I listened to my senior Anoche when he concurred that stated misbehavior is not defined. And you see, someone like the former Chief Justice, Sophia Kufo, respectably, has applied this same provision when this same stated misbehavior is not defined. So it gives a lot of room for discretionary application of what should constitute stated misbehavior. And so going forward, certain things must be made clear, certain provisions must be made clear, certain definitions must be made clear, and then the conjecturing when it comes to issues such as this will be minimal in terms of applying the Constitution.
What would it mean for polarization, especially when it comes to the judicial space? And like I've asked Lawyer Anoche before, perceptions that people already hold that if the Constitution allows for certain things to happen, even to such key figures within the political setup. This is number 3 of the country after the president and the speaker, and she was the Chief Justice. Then what could the regular Ghanaian expect of the judicial system, and how would that affect the trust that people have in these institutions and organizations?
For me, rather, it makes good of the fact that the law ought to apply to everyone, no matter your position. Nobody is insulated from, facing the law. The Chief Justice, that position, enjoys certain level of support, much more than what an ordinary citizen may enjoy when that person's position is threatened. So what it means is that no matter who you are, if the law must apply, then the law must be made to apply.
Okay.
Yes.
Hold the thought for a minute. Lawyer Noche, if you could, what does, the position of the former Chief Justice, for example, Sofo Akufo's argument, what does it add to the conversation when we are talking about, people being given a fair hearing and the safeguards that should be put in place for the next situation that may present itself with a petition, if another Chief Justice if a Ghanaian feels another Chief Justice has misconducted themselves?
Well, if I understood you, all that I would say is that if people belonging to that level, and I mean of legal thinking, could come out to doubt what is happening now, cast doubt on it, then it becomes very expedient for the whole nation to timeously, do something about Article 146, because it looks as if it was just another form of the 1960 situation where the president could summarily dismiss a Chief Justice.
So there was a systemic flaw, systematic flaw.
Yeah, they studied the 1960 Constitution, what Nkrumah did, and felt that people lambasted him all because it was very personal, that the president could dismiss the Chief Justice. So this time, instead of making it direct, that the president could dismiss the Chief Justice from office, this time, let's put some hedges there that he will cross, but not too much impediments. So it becomes necessary for us to do something. My brother was saying something which I like very much. In any case, let me commend him. It's like the two of us sat in the same classroom. Yeah, he said something I like very much, that if you could jump 7 judges and then appoint anyone below to make him the Supreme Court, the Chief Justice of Ghana, and that is what the Constitution says, because the president can appoint. He does the nomination and whatever. And the moment the president nominates, you are already appointed. If we had a situation whereby the justices of the Supreme Court, and for that matter, all the courts, will behave like what happens in the Ministry of Education. When I'm a senior housemaster, I know when I'll be senior housemaster. I know when I'll be assistant headmaster and the headmaster, without the regional minister coming in. In much the same way, when we knew that Bafoboni was the most senior judge of the Supreme Court, why do you go and appoint somebody below him to become the Chief Justice? All because the Constitution permits it. So the time has come for us to sit down and say that they know their hierarchy. So when it gets to your turn, even if you have to be there for just 6 months, it has come to your turn. And if you are not lucky that within the 6 months that somebody was the Chief Justice, your birthday, and then you go away.
Okay.
In that case, you took off the politics out of it completely. But for what we have today, as my brother was just alluding to, you have politicians appointing them, and then politicians to disappointing them.
Okay, so Abraham, I have a question for you. Should we time term limits of, Chief Justices to presidential terms so that we avoid situations where there is a perception that a certain president liked a certain Chief Justice, and so even when a petition is brought that may have merit, because of personal relationships and for political reasons, presumably, that person is let off the hook. That way, when the president leaves, the Chief Justice leaves, the EC chairperson leaves, and we know that the president is coming in with his whole new team. Should we do that?
That would be very dangerous for our democracy. The judiciary is our last resort. The judiciary represents our conscience and our soul, so that when things are not going right, even in our own homes, that is where we go to. Now, if we set that limit to the term of office for, say, presidents and all that, what it means is that the judiciary or the head of the judiciary now becomes kind of the likeness of the executive. So that I know that once I have come, I only have, say, 4 years. So let me do whatever it is. You know. But the fact is that since the judiciary represents our conscience, their work is insulated by the constitution from any interference, even from the president and parliament. And based on that, they are expected to work without fear of any interference. That is why at a point I personally had a certain mixed feeling about certain instances under the past Chief Justice. For instance, in the case of Afenyo Markin as the Speaker of Parliament, how the expert motion was heard and all that. As that is the kind of expediency we are all looking for in the legal system. However, that has not been so. And so, for me, if we should allow that kind of tandem term with presidency and the Chief Justice, it will be very dangerous.
Okay.
And the Chief Justice will appear to satisfy any president that comes.
A quick one, perhaps my last one to you before you go, because I have 2 more questions for lawyer before we wrap up this one. Abraham, what do you think about what this has done for us? Has it strengthened our checks and balances, or has it weakened our checks and balances, this particular removal of the Chief Justice? Quick one.
Yeah, I think that it has presented us with the opportunity to strengthen our democracy and to strengthen our jurisprudence. And
opportunity
so going forward,
strengthen.
Going forward, certain things will have to be done. Especially, it is good that we have the Constitutional Review Committee working, and so certain things will have to be done. Certain things will have to be put in place to make sure that some of these removal processes will be strengthened. And in the end, our democracy will be strengthened. If you look at our electoral laws, for instance, they have to pass through some of these stages for us to have, transparent ballot boxes and all that. And so, for me, I think that it is good in a way that it will help us to now strengthen our jurisprudence going forward.
Eko, thank you for the time we spent with us this morning. Eko Abraham is a political analyst. He's also a lecturer of law at UCC, adding his voice to our conversations for a political, twist to all this. Leonoche, we've kept going back to the fact that this is an opportunity for us to implement some changes. What kind of changes could we potentially be talking about? What should we be considering in order to do what we intend, an actual check and balance, and not, vindictive personalization, vendetta, and any of that?
Well, it is an advantage for the whole nation to understand why in almost every country the Constitution is only a skeletal document, not as big as the Bible. And then as you embark on the journey, you begin to do maintenance, servicing, everything. So now it has become so clear that we need to do something about, 1, the appointment of Superior Court judges, and then 2, the dismissal of Superior Court judges.
What happens to Tokonu now?
What has happened to Teku?
What happens to her now?
Now, nothing. She becomes like you and I, an ordinary Ghanaian. She becomes an ordinary.
She's still a lawyer?
She's a lawyer because she still has her practicing certificate, except where the General Legal Council will meet and say that because of ABCD, we haven't got there yet. But at the moment, she is an ordinary citizen of Ghana, but having a very beautiful accolade, a former Chief Justice. Because if you are listing the former Chief Justices of Ghana, there's no way you can jump her after any Yabua.
But in terms of benefits?
Benefits, she doesn't deserve anything. And I don't think they will give her anything. Because we all know, by way of procedure, that in any organization, when there is an opportunity for the powers that be to dismiss you, you can act smartly by doing what? Resigning. And when you are resigning, you give several reasons, or you don't give any reason. You say on personal grounds, which is also a reason, or education, going to educate myself, or on ill health reason. And this woman told the whole world that even though all her friends were advising her to resign, she felt they were all wrong. And she said she had to fight on because of her entitlements. Now she should go and claim her entitlements.
Well, the ECOWAS case is still pending. Yes. 2 other petitions are still pending. So perhaps we may get another opportunity to have another go at this.
Quickly, let us say that the 2 cases in law, we say they are moot or superfluous and redundant. They are not necessary because the president has gazetted the fact that the Chief Justice has been dismissed. And so whatever happens again is nothing. It's like the game of penalties. If you are able to score 3 goals and the other side shot nothing, you don't need to continue. And then when it comes to the ECOWAS one, that's where the Chief Justice erred. If I were her, I would have waited for
this outcome.
Very good.
Before
going in there so that you raise the issue of entitlements and the human rights, and a super one, because somebody like the president is going home without anything. Do the people of Ghana expect to see their former Chief Justice by the roads are begging for arms? That is where humanity will come in. Sentiment will come in.
All right.
But she put the cart before the horse.
Lawyer, thank you once again for sitting with us. Lawyer Anoche Frimpong has just tried to explain the effect of the removal of the Chief Justice on our democracy, reforms being drummed home, and we'll wait to see whether that happens or not. A conversation for another day. We'll take a break. Showbiz is next. Roverman is in the building.